Our next round of questioning is going to begin with Barbara Ernsberger, and this is a question about civil division. And this is a multiple tiered question, so if you need me to go back over any portion of it, I'll be happy to. Banks, insurance companies, brokerage houses, and the like are mandating that as a condition of a consumer maintaining an account with them, the consumer must waive his or her right to a jury trial, be bound by arbitration as the sole means of dispute resolution, and waive the right to initiate a class action. 3 questions with respect to this development. What is your opinion of this practice? Would you as a judge be willing to apply doctrines such as contract of adhesion or unconscionability to avoid such provisions? And 3, if your answer to B is negative, why not?
All right, that's a very complicated question. Let's start off with that. And because I've dealt with a lot of consumer fraud, so I'll start off with this. I have seen those kinds of provisions, and they're doing that at nursing homes, by the way. They pass them around for people to agree that everything goes to arbitration if they have a complaint. I always tell anyone that brings it to me not to sign it because I think they're waiving far too much and they don't understand what they're doing. They're waiving the right to go to jury trial, and also have their cases heard by a court and the right of discovery that comes along with civil division cases. So I would think that's a very bad idea. I think that in many cases, those provisions, especially when it comes to terms of finance, are going to be in tiny, tiny print somewhere, and people are not going to even understand what they're doing. So I suspect there would be good reasons and ways to set it aside. You are, by the way, not required, we won the case, you're not required to read an insurance policy when you buy it in this state, in case you're interested. That's under PA, because we won that case in PA consumer law. So I would be willing to, I would want to hear what the person thought they were doing and how it was explained to them at the time of whenever they signed up, whatever, anything that they did. And what was the rest of the case there? There were some more parts to that.
What is your opinion? Would you as a judge be willing to apply doctrines such as contract of adhesion or unconscionability to avoid such provisions? And if your answer to B is negative, why not?
I would be, you've missed some, whoever wrote that missed some provisions that could be provided, but I mean, they're probably all contracts of adhesions. I'll tell you that right off the top of my head. And I'd be willing to look at that, but you also have a lot of rights under the Consumer Protection Act if it's done at the time of sale. I think people should look at that for these kinds of, those types of activities. And as a judge, I'd be more than willing to look at it, and I think the insurance industry would hate to have me sitting there, but that's beside the point. Because I tried too much of this stuff, they would know I was alert to their problems. Go ahead.
Well, I've dealt with that in the consumer rights context, and usually these clauses actually say that any dispute of these terms must be brought to arbitration. It doesn't bind one or the other. It theoretically binds both. But, the problem is these creditors and these companies, they don't even abide by it. They'll go and they'll sue a consumer faster than anything. I've used those clauses to get things thrown out of common pleas court, and it's never been followed up on by the company after that. So, it can actually work that way on the defense end, too. I don't think they're ever enforced. I think, you'd have a good forum non-convenience argument there. And as Barbara said, at least on the insurance end, you don't even have to read the thing. So, sure, contracts of adhesion can apply, as can defenses under, for example, the Retail Sale Installment Contract Act, the Fair Credit Extension Uniformity Act, and all sorts of other state and federal statutes. So what I'm sort of saying, I guess, is that your question doesn't matter that much at the end of the day.
I spent a large chunk of my career suing insurance companies and banks and other big entities. I do believe, we see them all the time in agreements, and they're becoming more prevalent, And they're the contracts we all get and nobody reads. Guilty here. So while I do think it is a contract of adhesion, you don't really have a choice. If you want the service or you want to work with that provider. I don't think, my memory at least, of the current law is that it supports a finding of a contract of adhesion. I think you have to go different routes, like through the consumer protection laws and those things to be able to overturn a contract along those lines.
I think the question was basically, would you be willing to apply the legal doctrine? And certainly the facts supported and warranted, absolutely. The other side of that is that sometimes those types of clauses are meant for alternative dispute resolution, and sometimes they're actually beneficial to the consumer. They're more cost effective, but not always. It depends. Perhaps you like to see, you see them oftentimes where they say if both parties will agree to resolve this issue outside of the court system. If both parties agree, a lot of times it's done much cheaper. But I certainly think that people have a right to be careful of waiving that right.
I think the question envisions manipulative practices that are taking advantage of people who either don't have a choice or don't understand what they're signing. And part of the reason why we have courts is to correct injustices. As a judge, I would use whatever legal tools were available to me, including the doctrines mentioned, to correct injustices if that's what was happening.
Mr. Tranquilli.
20 years ago, when I started in the DA's office, we had trouble keeping jurors over in the criminal division because there were so many jury trials being picked over in the civil division that they kept cleaning us out. And that has eroded over the last 20 years noticeably. So much so that at one point our county executive proposed to eliminate 2 of the 4 seats that all of us are seeking right now because the civil division hasn't seen the kind of volume in jury trials that it used to have. I personally don't think that's a good thing. I think there's no problem with setting a dollar amount, on a jury trial. But I think that at the end of the day, people don't read a lot of these contracts. Who has time to sit down and read a 7-page contract with tiny print without an attorney standing beside them looking over their shoulder? And, at the end of the day, if somebody wants a jury trial and the dollar amount is worthwhile so that the public resources are not being wasted, then I say let them have a jury trial and trust to the common sense of the common man, 12 people that are sitting in the box.
Yeah, and I think if it gets to the level of a judge, first of all, I would certainly apply any remedies that were available and any of the contract remedies that the doctrines that were mentioned. And I concur with Mark, a lot of these documents, you're signing and some of this stuff is buried in fine print and you don't realize, you may not be required to read it, but you don't realize you're signing away your rights. And so if it gets to a point where it's a matter before a judge, I would certainly, the person should be entitled to adequate remedies under the law. And I think a couple of my colleagues mentioned that the consumers do have rights and protections as well to follow up on. Thank you.
There's been a series of cases involving pre-activity waivers such as skiing, snowboarding, where you waive your rights to collect. And the Superior and Supreme Court cases in Pennsylvania have watered those down, that you would have to show a knowing and intelligent waiver of the specific danger that was involved. And a lot of those waivers have been voided. I essentially would apply the same standard to these contracts as is applied to the Miranda test. Is it a knowing, intelligent, and voluntary waiver of the right? And did the person know they had a right to counsel? As far as my opinion of the institutions that try to impose these on consumers, I can't say it because I'm being videotaped, but if you would like to know my real opinion, just say I detest them.
I think the first part of the question about what is my opinion of this practice? And I think you referenced specifically being bound to arbitration. And arbitration really is a wonderful tool, I think, that in many circumstances, I serve as an arbitrator in the civil division. It can really save the courts a lot of time and a lot of money. But in terms of, what comes to mind is the recent Carnival Cruise debacle, where they said there weren't going to be a lot of lawsuits because they'd have to travel to some, unreachable location to file suit or something like that. I mean, there are provisions in the law to protect consumers if their, waiver isn't made intelligently. My willingness to apply doctrines to avoid such provisions, any that are applicable, would have to be decided on a case-by-case basis.
I would say that we're dealing with the interpretation of a contract here, and basic tenet of contract law is what is the intent of the parties when they entered into the contract. So the first thing as a judge you have to figure out, if somebody comes and says, look, I don't want to be in arbitration and what I signed requires me to do that, you would figure out by evidence, by testimony, what was your intent when you signed it. Did you intend to sign away the right to a jury trial? Because I said earlier, the right to a jury is a fundamental right we all have in this country. Be it in civil law, criminal law, or whatever, you have that right. So the first issue is, did you intend to waive that? The other part of contract law is, in this country, parties have the right to enter into any contract generally that they want to, as long as there's agreement. And they intend to be bound by the terms of it. And it can be oral or written. So to me, the analysis is, did you intend or want to be or have no problem entering into that? And if not, why not, and what are the circumstances surrounding that? And I would have no problem voiding that contract if, in fact, the intent was never to enter into it.
I am personally opposed to having those provisions in the contract stating they can't have a jury trial, because I believe, as Mr. Murray said, I think the right to a jury is a fundamental right, not only in criminal cases and in civil cases. But on the other hand, as a judge, I can't follow my own personal beliefs. I have to look at the facts and give a fair hearing. And I have to have, if an attorney came to me presented his argument, I would look at I want to present the facts of the hearing. I want to brief, see what the case law is in Pennsylvania on this. But without looking at that, I would have to see what the intent is. Was there a knowing, intelligent waiver? Did the person read the contract? I know, because most of those things are little provisions in fine print. I know my clients, when they're signing documents in my office, 90% of the time, they don't even read it. They just say, I trust you, Marvin, I'll sign it. I know that for insurance companies, I'm sure they do the same thing. So I would consider those remedies, but I would want to have a complete hearing and have briefing and then make a fair finding effect of both sides.